Good evening, everyone. I hope that everyone is having a great evening this evening, and I hope that your day has gone well. I wanted to take a moment and hop on with everybody and share with you some information about really what is a terribly sad day in the state of South Carolina. In fact, today is a terrible day for life in the Palmetto State because what has happened today has set us back. We had made such progress, and after having made such progress, we now find ourselves moving backwards in the arena of life in the Palmetto State. I'm going to ask you as you come in, click share, let somebody else know what's going on, particularly if you have Christian friends and family here in the state of South Carolina. If you know anyone who's pro-life, in fact, even if they're not a believer, if they are pro-life, we want to get the word out about what has happened here in the state of South Carolina and what that means for you. What that means is coming next here in the Palmetto State. So if you have not heard the news, the Supreme Court of the United States sometime back overturned the landmark decision Roe v. Wade, Roe versus Wade. That was overturned in the Dobbs versus Jackson case, and that meant that now states were going to begin to decide their abortion laws. Now, some time ago, in fact, in the last legislative session, the state of South Carolina had passed a heartbeat bill. Now, what that means is that once a heartbeat could be detected, that a baby in the womb was safe from being murdered in the state of South Carolina. It made it a crime to abort a baby after a heartbeat could be detected. Now, that was the law in the state of South Carolina, but it got held up because Roe v. Wade was still on the books at the time that that law was put into action here in the state. Governor Henry McMaster signing it into law. Well, then, of course, we know Roe versus Wade fell, and after Roe versus Wade fell, that allowed the Palmetto State's heartbeat bill to become the law of the land. But then, of course, we know, as tends to happen, those who are supportive of what we're going to just call what it is, the murder of unborn children, they obviously took the state to court to say that this heartbeat bill was illegal and was unjust to mothers in the state of South Carolina. And so today, the Supreme Court handed down their decision. Their decision was that, in fact, the heartbeat bill should be overturned in South Carolina. That means that now there is no legal way to stop someone from having an abortion after that heartbeat has been detected here in the state of South Carolina. Now, we look at that and we go, well, what happened? Well, here is the problem. The justices decided, their decision was based upon the privacy section of the state constitution of South Carolina. Now, some folks will get it confused because privacy was what had been attempted to be the supporting measure of the law when it came to Roe v. Wade. The privacy concerns for a mother were where many had banked on abortion being legal. But the Supreme Court said in the United States Constitution, there is no expectation of privacy in the United States Constitution. So, again, Dobbs v. Jackson, the Roe versus Wade decision was overturned. However, in the state of South Carolina, there is in fact a right to privacy. In fact, it's Article 1, Section 10 of the state constitution of South Carolina. And Article 1, Section 10 allows for protection from search and seizure. It also allows for undue strain on someone's privacy, if you will. And so the idea that a mother would have to reveal that she was pregnant and then make that decision in those about 6 weeks period before a heartbeat can be detected, that was seen by the justices to be an invasion of a mother's privacy. And because of that, the heartbeat bill in South Carolina that we all rejoiced about, that people like Representative McCravey worked so hard to get done, people like Palmetto family worked so hard to get done, South Carolina Citizens for Life worked so hard to see done. Those justices today decided, in fact, that privacy was more important than life. Those justices today decided that in South Carolina, you can murder someone and it's legal as long as you keep it private. Those justices decided that life is not as valuable as your privacy. Now, we all believe that every person has the right to privacy. We 100% believe that. We believe that people have the right to be protected in their effects, in their personal belongings, in their papers. We believe that every person has the right to privacy, yes. But that right to privacy does not supersede the right to life. And here in South Carolina, our justices today decided that, again, the only way that I know how to define this is if you can keep it quiet, you can murder someone in the state of South Carolina. Someone says, well, that's not the case at all. Murder's still illegal. Well, you can murder a child, an unborn child, as long as you can keep it quiet. I don't know what you think about that. If you have thoughts on that, drop your thoughts in the comments. I'd like to see what you think about that. I think that's ludicrous, that the idea that as long as I keep it quiet, I can kill someone. Now, again, this heartbeat bill was something that was worked on hard in the state, took time to get there. There were some that said it was not enough. And there were some that said incremental movement was not enough. But we were excited. I was excited. Most folks in the state were excited when the heartbeat bill was signed. I got to be there when that happened. Got to be standing in the room as Governor McMaster signed that into law. And what a great moment that was for our state. But now today, that has ended. Now, again, we have to understand the Supreme Court of the United States made its decision based on there not being an explicit right to privacy in the Constitution, as far as written in a way like South Carolina's is. South Carolina's law is written in a way that these justices have now interpreted thusly. Now, that does raise an entire other question that is not for this discussion, but that other question is about really about judicial process in the state of South Carolina, about how we arrive at our judges, how these people get on the bench. And that's a whole other conversation to have at another time. But if you've paid attention to the judicial system in South Carolina, we know that that's been a conversation that's been had again and again recently. And now we see these justices who appear to me to be activist justices interpreting the law in such a way that we're putting privacy above life. That doesn't seem to be good jurisprudence by any stretch of the word. But we find ourselves at this place. So now today, that law being struck down, we have to ask the question, where do we go from here? What happens next in the Palmetto State? And there's a few things that we have to notice. And again, if you're coming on, if you have friends or family in the state of South Carolina, click share so we can get the word out, let them know what's happening. We also want to educate believers as to what the process is for believers and what's going to be happening next, and things we can be praying about regarding life in the state of South Carolina. That being said, what's coming next is really going to be determined by how we view the law. First of all, one of the justices who was agreeing with the decision made a statement that essentially alluded to the idea that if it was just an outright ban, if there was just an outright ban, if it were just illegal to have an abortion in the state of South Carolina as opposed to the heartbeat bill, that has a point where it begins. If it were just illegal, where you didn't have to invade anyone's privacy to determine when and where, if it was just illegal, it would be like murder or rape or theft or whatever else is against the law. It would just be illegal. There'd be no privacy concerns and everything would be okay. And there are certainly many people who were calling for a total ban. And obviously, when we say total ban, we don't mean without an exception for something like the life of the mother. But there are many people who have tried to, again, conflate those issues. And of course, there are others who have tried to have exceptions for other reasons as well. That being said, he says, listen, if it were just totally banned, and one of the things that should be pointed out is this may be a genuine statement from this judge, but South Carolina has already proven that politically it doesn't seem like there's going to be an all-out ban in South Carolina. Doesn't seem like there's enough votes to get it through. Perhaps could get it through the House. Probably not the Senate, unfortunately, but we'll see what happens with that. That being said, an all-out ban could be the thing that would be pushed for that could overcome this idea of a privacy issue. The other issue that could be coming up would be moving. In fact, the decision when it was written, Justice Hearn wrote that basically 6 weeks was not enough space, if you will, for it to not be a privacy issue. So essentially, 6 weeks was not time for that lady to be able to make a decision with her doctor and it not be an invasion of privacy. So what that may mean for the state is that the legislature comes back and says, hey, 6 weeks cannot fit with the Constitution. And so they come back with a more extended time period, because it does seem that the way the decision was written, it would leave one to think that perhaps there is time. And again, the way it was written, there's time that perhaps 10, 12 weeks out, that there's been an opportunity for a woman to discover that she's pregnant, so on and so forth. And make that decision. Now, as a person who does not believe in abortion at all, I would say that 6 weeks, 12 weeks, 14 weeks, whatever that would be, that's not a place we want to go. However, if we have to go to 14 weeks right now to begin to stem the tide, then that may be what happens, or 12 weeks or whatever that number comes down to be, most likely 12. That being said, those are the options right now legally. Either legislatively, the state can attempt a total ban, or, which is not likely, we just saw it attempted and it didn't seem to be able to have the votes, or there's a ban at some time after that 6 week mark that may satisfy the judiciary. Now, there's also the concept of working on the Constitution, constitutional amendments dealing with that privacy section of the Constitution there. Also, we've seen states work on constitutional amendments to protect life. And then, of course, in South Carolina, we've got a big issue with judicial review and judges, and how we wind up with activist judges out here legislating from the bench. The legislature has made its decision. Legislators voted on by the people of South Carolina, decided this is what we want in South Carolina. We want this heartbeat bill. The governor signs it into law, and now we have activist judges who say, hey, we're not going to stand by that. So there's a lot of things that we could look at as we move forward, and we see what the future holds. So be in prayer about those next steps. Be in prayer for your brothers and sisters that are in the legislature, that God would guide them and give them wisdom. Be in prayer for those who are laying out the strategy on these things, the legal strategy. The enemy would absolutely love to blind the minds of the men and women who are going to be making these decisions. and they need your prayers so that they can have guidance and so that they can make wise decisions in the days ahead. So for Christians, that's going to be our responsibility right now. It's going to be encouraging our legislators to keep up the good fight. And it's also going to be in prayer for them to have wisdom, be in prayer against the spiritual powers and principalities that push something like that in our state. Be in prayer for the souls of the people who are promoting the murder of the unborn in the state of South Carolina. And also, we have a responsibility, and this last responsibility comes down to the preachers and the teachers and the pulpit, and that is, in South Carolina right now, abortion is not going to be illegal, or at least as illegal as it was. Right now, the law has been pushed back. So, but rather than attempt to make it illegal, we have to make sure that we are teaching and preaching and discipling so that the murder of the unborn becomes unthinkable. So it's an untenable idea. So it's not even part of our vocabulary. And that's going to mean getting back to discipling people in a biblical worldview. So again, a sad day today for life in the state of South Carolina. There's a few options that we have coming out of this. And the number one thing for believers to be doing is encouraging our legislators. That's the number two thing, encouraging our legislators. And the number one thing is be engaging this issue in prayer. I do so appreciate your time this evening. I just wanted to hop on and talk about it. Life and the issue of life has been close to my heart. And again, today was a sad day, but I know that God is still in control, and I know that there's still good men and women in the state of South Carolina that are going to vote and are going to pray and are going to preach and teach and disciple and do all of those things. God bless you all. I hope you have a great evening, and keep praying for unborn lives in the Palmetto State.